But here, physically, does anyone have any question concerning, oh, thank you very much. I see hands already coming up. So, Mr. Alex, I would like you to please come up to just answer a few questions. Sir, please, you can come forward, please. So we'll just have you captured online because we have a lot of people online. So if you have a question, this question and answer session is supposed to last for just about 7 minutes. It's supposed to be very brief before we move on to the panel session. So please, hello.
Yeah. Special recognition to senior advocates of Nigeria present and colleagues. My question is directed at the Commission. You mentioned something about certification for DPO. Not a lot of publicity has been put out around it. I have been looking around for it for a long time. How much is it going to cost? What's the length of the training? These are my questions. Thank you.
Okay, so if you are following any of our social media handles, you will know that there's been a lot of awareness in this issue. And of course, we rely on everybody, as you heard it today, to also help us put that message out there. So the national certification process is something that just is not up to a year now that it has been initiated and is in its perfection stage right now. You know, we sometime, I believe it was early this year, so we opened applications and we were able to train about 500 out of the initially planned, almost about 5,000 we planned to train to certify them as data protection officers, but we ended up training only 500 and they wrote the certification exam. And the reason is because, you know, money. To do these trainings and everything cost money and all that. So there's going to be another phase of it. And of course, we are working directly with IIM to be able to bring this certification program to everybody. So very soon, everything about the information is going to be put out there for those that who wish to pay for. I think the fee should be around, probably around 500,000 or so to pay for it, to be able to write the exam. And just what you can do is to really follow up on any of our social media sites. We are always posting every activity of the commission there. Thank you very much. Hope that answers your question, sir. Okay. We can answer it fully if there's any part of it that you feel you didn't need, wasn't really addressed. Huh? Oh, duration. You will get that. You know that when the time comes. It's not been, like I said, it's still in the perfection stage. Okay. Yeah. Yes. I agree. I very much agree. Yes. Yes. I very much agree with you on that. Thank you very much.
Thank you very much. Please, I'll come back to you.
Thank you very much. My name is Olumuyiwa Akimburu SCN. I want to find out from you while you are delivering your lecture. You said a lot of things about process of usage of data you have collected, and but you didn't say anything about whether it is possible for for you to pre-obtain consent of the data subject. I mean, if you, while you are collecting data, whether it is possible to have pre-obtained the consent of a data subject so that at the time maybe you need to release it or whatever, you may not have to go back to the data subject.
Okay, sir. You can't pre-obtain consent of the data subject, you know. as a data controller, if a data subject, requires your services and there's a need for you to collect your data, like I said, one of the rights of the data subject is that you have to inform the person at that point of collection what you need their data for. And of course, if you are collecting data, that means you must have identified a purpose for which you are collecting the data. Yeah. And of course, the consent you are going to obtain at that point is to process that data in line with the purpose that you have collected. So that is how it really works. Maybe I didn't understand your question well, but okay, maybe you need to.
Okay, like if I'm obtaining data now, or maybe a certain group of people, is it possible that in that agreement or while informing them that this data may be used for A, B, C, and D, and you have an option to either proceed or not proceed? That's maybe like a pre-obtaining a consent. So if they proceed and you use it for that, you don't have to, you still have to go back to them.
As long as you have informed the data subject the purpose for which you are collecting their data and obtain their consent at the point of collection, you are good to go. That forms your legal basis. What you now need to do is to be able to demonstrate that consent when the time comes. And of course, don't process it outside those purposes that you've told them. If you are going to use it for any other purpose after that, you have to go back and collect their consent again for a new purpose that you have identified. Yeah. So, yeah, no problem.
All right, so I'll take 2 questions online and then also proceed to take a few questions here too.
So just in addition to what my colleague had already brilliantly explained, even under the Act, it states that there can't be pre-selected confirmation. So you can't pre-request for the consent. It has to be at the time that you're actually collecting data. And just to know that consent has to be specific, it has to be explicit, and it has to be informed. So the way you're asking for that consent is very important. You have to express in a way that they can easily understand it and make an informed decision. So even pre-selected tick boxes, we will not classify that as consent. So thank you.
Thank you very much. The question I wanted to ask was the question Leonard Silk, Mr. Olumuyiwa Akimboro asked, but the other part is not a question, it's more like an intervention. When you were making your presentation, you identify a lot of areas that lawyers can tap into. And you also identify that the people practicing in this space currently in Nigeria has a shortage. I think part of the report, like a communique that you may have to take back, is to partner with the Nigerian Bar Association, YLF. There are a lot of young, vibrant, intelligent lawyers who will be interested in the data protection space. Now, I was very happy with the question that talks about the amount. 500,000 is a lot of money, especially now that you have identified a shortage. I think it behoves on the agency to close the lacuna. And you have a catchment area within the YLF who you can come up with a rebate or even say, okay, for a startup, we are sponsoring 1,000. And then when people begin to see the opportunities in that space, you now begin to make money from trainings and all. I think it will be very discouraging because people that are interested in tech and data are the young people. Now, you're talking about tech and data and you're putting 500,000. You're talking about the certification abroad for 1,500. People will run away. So for a country that has shortage of practitioners in that space, I think it behoves on you to come up with a package that will drive their interest. And subsequently, young people will market you. And then you begin to make money from it. Thank you very much.
Thank you very much.
Can I just quickly reply to that? Okay. So I hear what you're saying, my Leonard colleague, and you are right to some extent. But I don't think the 500,000 is too much. I'm not a big man. I'm not a big man. But the truth is that I don't think the 500,000 is too much compared to what is obtainable. If you want to write these certifications outside the country, you pay times 3 of that. You will pay times 3 of that. You understand? Okay, let's not go into that area right now. Let's not go into that. Okay, on the other part that you mentioned about partnering in the NBA YLF, I think that's part of what you're already doing here. You know, collaboration and cooperation, of course. And when we open the opportunities again, it's not just going to be just for the young lawyers program. It's for the general public. When we opened the portal to receive the first set of data protection officers that we trained, we wanted 500 and we received over, if not more than 1,000. And initially, if we had the funds, all we planned to train was 5,000. And that is still going to happen. We've only trained 500 out of the 5,000 we're going to do. And that one, we are doing it free. Yeah, we're doing it free. So many of you should look out for our handles for when the next opportunity comes. You can benefit without paying anything at all. But if you feel you can't wait and you need to go out of your own way to get your own certification for your own private, you know, whatever, explore the international certifications or come for the local one. Whichever one you go for, you are good to go. Thank you very much.
Thank you very much. Just to add to this, I'm sure when my alternate chair, Uchenna, comes up here, he's going to throw more light to this. We actually had a meeting yesterday with the commissioner of NDPC. He was ably represented by his legal head, right? And he said that they've gotten our message because we actually tabled this particular issue to them, and then we also made them understand the benefits of having young lawyers on board, because most definitely young lawyers are the future of the legal profession, and then data protection is also the future of the legal space. So it's just necessary that we as young lawyers are equipped. And just so I don't waste so much time, I'll just scan through our chat box here and ask a few questions from the online community, because I see over 60 messages, because we have almost 500 persons online. So I don't want them to feel left out. So I'll just take 2 questions. Our online people, please do not be angry with us. We don't have so much time, so we'll just take it up and then move on. So the first question here, people are asking if you can get the slides. It's okay, so we would make that available and then we would revert to everyone via our correspondence channel with the NBA YLF. So as a first question I'm reading from the online community. So as a speaker from an NGO who visits school and take groups pictures with the pupils, are you breaching any provision of the rules when you post such pictures on your profile or use them for NGO activities? Thank you.
Okay, I would say that to some extent it depends on the activities of the NGO. If they are carried out in the public interests, you know, to some extent you might not be breaching the obligations of the NDPA Act. But aside that, normally, we are the commission. What we do when we receive people or we are going for things like this, we usually inform everybody that, okay, we have our media team here and we are going to be taking some pictures of you, which you are going to see somewhere after now on one online page or the other. And we ask them, do we have your consent to take your pictures? And we allow them to respond. If they respond, that is sufficient for us. So for the person saying this, I will advise them to also do the same thing. If they're going to be posting pictures, which of course picture is a personal information, is a personal data, you know. So before you post those pictures and everything, so that you don't get anybody aggrieved or run into issue with the NDP Act, always inform these people at the point where you're organizing these programs and stuff, you know, tell them that there's going to be a media coverage for this thing and it's going to be posted on some places, and seek their consent at that point. Ask for their consent at that point. If there's a cameraman already recording, when they respond, of course, you've gotten your consent and you can proceed with that. Thank you very much.
Thank you very much. I'll just take this last question. Consent is obtained. Okay, no. Most of the questions here have largely been treated one way or the other, so I would not ask them again, so I would not belabor us. So I'll just move on. I will just proceed rather to the panel session with our representatives from the NDPC and D-Plan. This session will be moderated by our alternate chair, Uchenna. Please put your hands together for Mr. Uchenna. No, please have it. Okay. So I would like Mr. Alex and Miss Owu, please, if you just join us here. And Mr. Moaz, please.
Hello, everyone, once again. I am certain that personally, I have had a very enlightening session, and I am sure we have all had a very wonderful session. We've enjoyed ourselves, we've learned, and we are still learning. So, the very crux of the matter when it comes to data privacy and data protection is first and foremost the issue of awareness. You cannot protect what you were not aware of, what you do not know. Right. So the very first step, as I have always preached, is to enshrine a privacy culture, to make people understand that first and foremost, your right to privacy is enshrined. It is your right to not have your privacy infringed upon. It is when you are able to acknowledge that right, then and only then can you go on to protect it, right? That is the first thing. Then moving forward, of course, during the question and answers, the issue of the cost of certifications came up. And it would interest you to know that yesterday, the committee, the Emerging Practice Areas Committee of the MBA YLF, paid a courtesy visit to the commission, where we were received by the head of legal who was representing the national commissioner. He was unavoidably out of the country. And it was a very wonderful session. We spoke to collaboration between not just the committee, but the YLF, the Young Lawyers Forum, and the commission. We cited several reasons, particularly the mere fact that the idea of data protection, and I will speak to this as young lawyers, the idea of data protection speaks to tech. And there is a certain culture in our space where when you speak of tech, they always tell you to go to the young people. They're the ones who their brains are hot, they can do this, right? So it is very important that young lawyers are able to hold their fort in this area, are able to know, understand, because it is then through them that you can reach out to not just their seniors in the profession, but their clients as well, and in fact, everybody who is around them, right? And we also spoke to not just collaboration, but we appealed for a certain level of leverage, a certain level of, we don't want to use the word discounts, but we just asked the commission to look into the idea of creating a concession for young lawyers for these trainings and certifications, and we are hopeful. And again, Mr. Alex and sorry, what's your name? Mr. Bukunias, forgive me, I am terrible with names. We are hopeful that we still take our message back to the commission to remind them of our discussion yesterday, because it is a very necessary, discussion to have, and something that would, because the idea of privacy is not just our concern, it's a national concern. Our data is harvested and processed in other countries, and it is a national security concern as far as I'm concerned, right? So we hope that going forward, we'll get a positive reply from the commission. Now, going forward to this panel session. This panel session is under the subtopic, or is for the subtopic, framework of the NDPA. Yesterday we were told not to call it the NDPA, call it the NDP Act by the Commission, so it is easier to identify. So, framework of the NDP Act, particularly regulation and compliance. So, having said that, I will dive straight into the questions for our panelists. It is a discussion, in fact, not just question and answer. It's a discussion, an ongoing discussion, which we intend to have. So, the very first question I would ask is, and I will direct this to you, Ms. Ibukun. It is so for a period before the NDPA, the NDP Act, again, forgive me, came into force of habit, came into operation. We had the NDPR, right? Now, the NDP Act came into operation. After that, as at this year, I think around April, the NDPA Act Guide, came into operation. Was promulgated by the NDPC. Now, these are building steps to enforcement and compliance, but it still raises a very important question. How effective are these existing frameworks? How effective are they in addressing modern challenges, especially when it relates to AI, for example, or other emerging areas? For example, another example would be blockchain, where the very existence of blockchain, the data there is immutable. And data privacy, at the core of data privacy is the right to forget, the right to erasure, right to rectification. So how exactly do we create a balance between these areas? Thank you.
Thank you very much for that question. Good afternoon, everyone. Very delighted to be here. And the MBA is a very important institution to us. We have seen a lot of questionable data processing practices by the MBA. We've discussed it. So we're happy that this is going on now, so that at least we can raise awareness and educate young lawyers on what the obligations and compliance measures under the law are. So now to your question, whether the existing laws and obligations address modern technologies. Short answer, yes. But before I answer, I just wanted to note that the NDPR now is not a regulation that the Commission would now consider anymore in looking at application of the law. So if you look at the NDP Act Guide, there's a provision there where we state that the NDPR will no more be used in interpreting the law. However, it doesn't mean that cases in courts now or issues that arose when the NDPR was still in operation would not still be existing or going on. But going forward now, any new issues or applications arising after the issuance of the NDP Act in March 2025 will now be resolved using the NDP Act and the NDP Act Guide. So in answer to your question, I will refer to certain sections to show how the laws actually address modern technologies. If you look at NDP Act Guide, Article 33 in particular specifically deals with emerging technologies, yes. And in summary, what it's saying is that you should ensure that certain organizational and technical parameters are definitely taken note of and complied with in using artificial intelligence. And to what you said about blockchain, there's actually expert provision that says that the right to be forgotten, you need to ensure that while using AI or emerging technologies, you actually ensure that there are measures in place to allow data subjects forget their right, exercise their right to be forgotten. And also that data subjects should not be subject to decisions solely based on automated decision making. So if you look at that article very well, there are various obligations that you have to comply with. One of them being making sure that you actually have a DPIA in place. And what does a DPIA mean? My colleague already discussed this when he was giving his presentation. It basically means an exercise you go under to when you're going to employ new technologies that will consist of data processing on a large scale, or if your data processing will result in high risks to the rights and freedoms of data subjects. So for example now, if a bank wants to introduce a new loan application and they're going to use some sort of artificial intelligence technology to be able to decide who would actually be entitled to this loan. That would probably be done on a large scale. So if you look at the context, the scope of that, if it's Access Bank, for example, how many data services does Access Bank have? They have so many customers. So it's already going to be large scale data processing. You're going to be using artificial intelligence. You'll probably be taking information that if it goes out, there will be a risk to their rights and freedom. So in this instance, you have to go to the DPIA. I wanted to go into what you have to do for a DPIA, but I noticed that it's one of your questions, so I would not go into that so that I don't state that yet. So that's Article 43 of Guide. Article 28 of Guide now talks about a DPIA. So when you're actually supposed to, it lists the different instances when to conduct a DPIA, and one of them is the use of artificial intelligence and emerging technologies. And then it lists what you should do in conducting a DPIA. So that's for Guide. And then finally for Guide, there is a section that talks about vulnerable groups. One thing that people need to understand when you're using a DPI, when you're using emerging technology or artificial intelligence, there is a high risk of bias or disparate outcomes, because most times what people use, the data sets you use to actually feed into these technologies, they're not very inclusive, or they don't consider the full group of people. And because of that, when you put in information, the answer it gives you may be biased, or it may not actually consider the full extent of the particular context that you're considering. So based on this, Guide says that when you are using AI and many technology, you should consider vulnerable groups. So people that vulnerable based on their financial situation. Children are vulnerable groups. Sometimes even women can be considered vulnerable in certain circumstances or contexts. So in these instances, you have to put in security measures in place to ensure that they don't actually go through any disparate outcome or outcomes that are not beneficial or advantageous to them. So that's for Guide. Then under the Act itself, if you look at Section 37, that is the right to not be subject to automated decision making. My colleague already spoke about this. Under that right, it states that you should not be subject to automated decision making without any human involvement. So I'll go back to the loan application now. If, for example, I want to get a loan with Access Bank and I use a system that already has an AI sort of plugged into it to be able to assess whether or not I qualify for that loan, at some point in that process, there should be some human involvement. So maybe what the AI can do is it puts in the information, it assesses my credit scoring and everything to see, okay, if Bukun qualifies for the application because she's always paying her, interest on time or loan balance on time. She normally gets this particular salary amount, so she has the money to afford it. After getting that, there should be maybe like an HR personnel that will come in to still look at the application and make a decision. It shouldn't just be the AI that will do that. There are exceptions under the law where it says that if I've given consent, and you know what, just use AI, don't have any human involvement, or in instances where there's a law that states that you can only use AI for that, then it allows it. But generally, no decision should be made against the data subject automatically without any human involvement. So that's for NDP Act Guide. Then Section 24, that's the principles. I will not go over it because my colleagues spoke about that. But if you apply the principles to data processing when using AI, you will see that it actually protects people. Then Section 25 talks about the legal basis for data processing. So what are you relying on? Is it consent? Is it public interest? Is it vital interest? Is it contract? Is it a legal obligation? You have to make sure that you identify this and you inform data subjects. And then finally, sections 34 to 38 that deals with all the rights of data subjects. In using modern technologies, you have to ensure that you have put in systems in place to allow data subjects to exercise their rights. For example, you spoke about deletion of data and right to be forgotten. How are you ensuring that data subjects can actually implement this? So is there a process in place? Like, are you providing maybe an email that says that if you want to delete your data, you can reach out, you can send an email to this, or fill in this form and ask for what right you want, and we'll get back to you. So you need to ensure that while you're using the many technologies, all these mechanisms to implement these rights are in place. Thank you very much.
Thank you very, very much for that very insightful answer. While you were answering the question partially towards the end, so I take it that what you were speaking about spoke particularly to the idea of privacy by design and privacy by default, That's what you're speaking to towards the last. I will engage you on that coming forward, but before then, Mr. Musab, sir. So now, speaking on AI particularly, most people use AI a lot, especially even young lawyers, not just young lawyers generally. Now, there are situations or there are occasions where they willy-nilly put in the details of their clients, maybe to create a brief, to get a draft, or they put in these details without consent, or even without their client's knowledge. Right? What do you think, about this? Is it a breach of privacy? Especially when in regards to LLMs, for example, ChatGPT, the free LLMs particularly, these are large language models, that's what they're called, LLMs. So what do you think about this?
Good afternoon, everyone. Thank you for this question. I think it's not only about breach of privacy. Rather, the question will be, is it ethical? And what are the ethical concerns, or what are the ethical implications of putting someone's personal data on that platforms, most of the time generative AI? Looking at it, I think there is AI, was it practice also issued by section of legal practice, MB, right? Framework for how to use AI. So I believe looking at the provisions of that, you can see that it didn't prohibit the use of generative AI absolutely. But there are ways that you can use it. One of such ways, as we have under principles of data protection, we have purpose limitation. No data minimization. You have to minimize the amount of personal information supplied to that. Also, you have what we call data anonymization. If, for example, I want to mention Mr. O, prompt given to the AI, I can decide to say Mr. O. By that way, you can avoid supplying necessary information at the end of it may indicate you as a lawyer. So the best you can see your scenario, you agree, without putting the personal information or the necessary information that in one way or the other, because you know where that data is going, don't know what's going to happen next. As I mentioned, every things are changing. Every things are happening. So as a lawyer, and particularly young lawyer, you have to be extra careful with what you post, particularly on this generative AI. I hope I answered your question.
Thank you very much, Mr. Musab. Thank you. Mr. Alex, do you have anything to add to what you said? All right. Thank you. Ibukun, do you? Okay, please.
Okay, thank you very much. In relation to what you said, which are very valuable, and I'll be picking back off that. So I wanted to just put it in practice, what he said about not imputing the personal information, but still using artificial intelligence to get what you desire. So that's where privacy enhancing technologies come into place. And I'll give you an example. We have use of synthetic data. What does this mean? This means using fake data to get what you want. So let's say you have an hospital and they have a database and they also have artificial intelligence that they want to be able to use. They want to be able to impute symptoms of data subjects for the artificial intelligence to now tell them what the diagnosis is. But you don't want to put their actual names and what they have. What you can do is you can look at the age ranges of people. So let's say maybe everyone there is between the age of 18 to 25. Instead of putting Ibukun has this, so what does that mean? You can put we have a group of individuals between the ages of 18 to 25 that have this. What would their diagnosis be? That is insane. So you've indirectly, you haven't put their personal information, but you've given the AI information needed to be able to come up with what the diagnosis will mean. So that's synthetic data, right? Another means is by tokenization. That's when, and you see this a lot in financial institutions and industries, when they're trying to aggregate data or use artificial intelligence or just anything to do with data processing, but they don't want to use the personal information of people. In instances where you would normally put maybe my name and my card details or my address, they would just put different numbers. They can have a system, maybe they'll say B12222, and then they use that to be able to identify people. But in using this, you still have to have another system in place that you can always go back to be able to re-identify the individuals. But the good thing about that is that when you put in the tweaked version of the information into the AI, you're indirectly protecting data subjects. Then you have anonymization, you have pseudonymization. So those are the sort of techniques that you can use to ensure that you don't actually impute the actual information of data subjects to protect them. Thank you.
Thank you very, very much for that. Thank you so much. Now, usually when it comes to the use of these emerging technologies and the rules that are regulating them, there seems to be I wouldn't say paucity, but there are rather, now, for example, most of, if not all, but most of the rules regulating data privacy, especially the early ones, seems to be a compromise between big data, big data companies and, data privacy principles, particularly, right? Now, here in Nigeria, unfortunately, to an extent, we are somewhat, it would seem, now, I will not make an all-conclusive statement, it would seem that we are playing some sort of catch-up, right? It would seem so, right? Because of the fact that as we make the laws, the technology continues to develop, right? So we are in a perpetual, for now anyway, state of catch-up. Especially even as it relates to other, jurisprudence, other countries now. So what is the current state of Nigeria's laws as it is, or as it were, in relation to global advancements like the EU AI Act or the US Take It Down Act? Mr. Alex, could you take this, please?
Okay, thank you very much. I can't say that I can speak directly to the EU AI Act in totality, but I think part of your question is on challenges, right? Yeah. Of course, part of the challenges we are facing in Nigeria at the moment is the fact that, as you know, the NDP Act is just 2 years in existence right now. So, like you said, I agree with you. We were actually playing catch up, but I believe to some extent we've been able to catch up. Yes. I would dare say that to some extent we've been able to catch up, especially with the enactment of the NDP Act, with the coming into force of the NDP Act. So my colleague has already mentioned the provisions that pertain to this AI and all that. I think part of the challenges we have right now with enforcement and all that is, what I say, low awareness. Low awareness, We have low awareness in this area. People don't know how AI is used and how it can affect them. People don't know their rights in relation to the NDP Act as it concerns AI and all that. And this is why we welcome situations like this, whereby we're able to speak to people like the Young Lawyers Forum. We are, the Commission is actively engaged in accelerated mass awareness all over the country. Radio jingles, billboards, whatever we can lay our hands on. We just want to put the message really out there. So the problem we have is low awareness. And of course, we don't have enough workforce in this ecosystem. There are so many, I think currently we have even been able to identify about, if not up to 1,000 or more data controllers and processors in Nigeria. Probably more than that even yet. And we have limited people who can serve as data protection officers in these roles, So there are shortage of data protection officers in Nigeria. So, which is why we came up with this national certification program to be able to bridge this gap. Of course, your consideration as to that area has been taken up. Will be taken to our national commissioner. So part of the problem, like I said, we have is low awareness. I think this message of data protection needs to be taken down, even down to the roots. Down to that Aboki man that used my friend's company account details to Rapsuya. You understand? They need to understand the implications of what they are doing and everything. I think that's just my contribution there. Thank you.
Sure. Okay, just to know that there is an advantage of playing catch up, and I think it's important to highlight that. The good thing about the fact that our act came out a little late is that we were able to survey and really consider everything going on in the ecosystem. Our act has been noted, both locally and internationally, as one of the comprehensive and most progressive data protection laws in the world. And we would not have had that advantage if we had, established, enacted this act earlier. For example, I think there's somewhere in Africa, I think it's Kenya, where under their data protection law, for you to make any change or amendment, you have to go back to parliament. So as the law is evolving, they're always going back because they came up with a law quite early on and it's not comprehensive enough. But because we've had time to actually look at the ecosystem, look at everything that is going on, our law is quite comprehensive. You might even see instances where our provisions may not state specifically that to apply something, but if you look at the purposive intent and look at it holistically, you see that there's a provision to actually deal with every single part of emerging technology that's coming up. And then there's no African country that has come up with a document that is as comprehensive as NDP Act guide. And I would encourage everyone to please look at it and you see how comprehensive it is. So just to know that we actually have good laws in place and there's an ability playing catch up. Then just to know that the Ministry of Communications, Innovation and Digital Economy actually came up with a national artificial intelligence strategy document, which talks about the responsible use of AI. So we also have that law in place. So we actually have comprehensive laws. I think it's mainly just compliance and enforcement that's our main problem, our main issue. Yes. Then sorry, just one more thing. The Takedown Act that you mentioned in the US that states that when you found the data controller to be in breach of the law, you can actually tell them to take down that particular, information. You can do that on our act as well. If you look at our enforcement provision, section 47 on compliance, that's one of the orders that we can give. And guide also allows us to do that as well. Thank you.
Thank you very, very much. That is a very wonderful answer from the both of you. And now, Mr. Musa, back to you. So, as young lawyers, it comes with the field that as a young lawyer you are always caught between, and I say this from experience, and I'm sure most of us who are young lawyers have this experience. You are caught in between trying to, for want of a better word, between passion and profit, right? Where you have a passion for something, right? But as at that point, you are not entirely profiting from it. So I have met several young lawyers who have passion for these emerging areas, for example, and they are in firms that either are entirely traditional or do not particularly have interest in these practice areas. So how does a young lawyer navigate the intricacies of this particular dynamic? Thank you.
Thank you. I think once I found myself in this dilemma, yes. Because I started developing interest as far as technology and law concerns since my 300 level when I had application of computer to law. Then we don't even have much. Just then, the Cybercrime Act is just coming up 2015. And that is how I got started. After NYC, I work with a law firm in Kaduna. And basically, they are just normal law firm into litigation, going to court, property, and interest. But how did I find myself from cybercrime to data protection and now AI? So what I did actually is you have to work hard and balance between passion and profit making in such a way that you have your goal, you have your plan, you know what you want to achieve. Because I learned computer at an early age. That is one of the advantages I have. So when I grow up, I didn't find computer something strange. And I just continue with what I'm doing from cybercrime, AI, data protection, metaverse, and all of that. So as a young lawyer, you have to first put it at the back of your mind. You have to balance between the two. You need money to survive. At the same time, you have your own passion. And this emerging area, particularly for young lawyers, you have to invest most of your time, and the gain will not come as early as you think. So you have to be patient. You have to be consistent. I think I mentioned earlier in the morning, in the afternoon, yes. And you have to understand the intricacies of the emerging technologies. By doing that, you are making your money, livelihood. At the same time, you are building yourself in that particular area of emerging technology. Before you know it, one night, you just boom, wake up and see yourself in where you never expected to be. Secondly, regarding our law firms, you have to encourage our principals to understand that these emerging technologies, they are here to simplify our work. They are put in place in order to solve most of our problem and minimize the resource, both financial and time resource. And I also think that the problem we are having young lawyers is over-sabi. We always try to show that we know. And these our elderly men, our fathers, our senior colleagues. Someone has been there before you are born, and you just wake up and tell him this is how it's supposed to be. It doesn't work that way. You have to convince them that, sir, look at this. Doing this, doing that, like my office. Now, if I prepared a process, I'll just share it with them. Initially, it was email. Now we have Office Drive. Every one of us is on that drive. Why? Because before you have to send it to them via WhatsApp. They have to transfer it from their WhatsApp to their system. Now we now switch to email. When you send it to the email, they have the email in the system. They can now open it and do the correction, then send it to the secretariat for printing. But now we have Drive. The moment you finish your work, you just put it in the drive. Just send a message that I have finished this process and I name it so on the drive. From there, you have access to it. Wherever your principal is in this world, he can just access it, make correction, print it and file. So now there is no longer excuse of extension of time that the principal or the person handling the matter is travel out of the country or blah, blah, blah. And so as a young lawyer, you have to, I always say this, one of my mentors mentioned it, that you have to think globally and act locally. You cannot have the same solution to the same problem. Our peculiarities matters, so think globally, look at how other people are doing this, and look at your environment to see how you can put that particular. I think this is the little I can say.
Thank you very, very much. That was very, very wonderful response to the question. I'm sure not just me, but other young lawyers, both those who are with us here present and those who are online, have learned one or two from it. Now, for want of time, I've been signaled like 7 times already. I'm going to ask one final question and this is both to you, Ms. Ibukun, and Mr. Alex. Over and over again, we have mentioned, in fact, we even mentioned in Terero's first question you answered, it was part of it, the DPIA. Yes, so what is the DPIA? What are the key steps in the DPIA? In fact, showing it more forward, what is the data protection audit? Because these are, first of all, terms that are thrown around in the sector, and these are things that as a person or a professional in data privacy, in fact, as a lawyer who is interested in compliance, generally now, audits is something you must be very familiar with. So bringing it down particularly to data privacy and data privacy compliance, how do you conduct, what are the steps in the DPIA, and what is the data privacy audit? Thank you very much. So both of you, thank you. I will start with, okay, ladies first, thank you.
Thank you very much. So I would state the section in the Act and NDPR guide that deals with it, so that if we're not able to see everything, you can always go back and look at it. So Section 28 of the NDP Act talks about data privacy impact assessment. It talks about when it is needed. So you have to conduct a DPIA when your processing may likely involve in high risks to the rights and freedoms of data subjects. You have to conduct a data privacy impact assessment. Now, what is a DPIA? It's generally an audit exercise for you to understand your data processing in depth and for you to be able to understand the risks that would occur and then how you can mitigate these risks. So what are the steps? The first thing you would do conducting a DPIA, okay, before I say this, in an organization, generally, DPIA should be championed by a data protection officer. So basically means that that officer will be the one that would initiate the process. However, they can't work on their own. You need to work with the legal team because the legal team would identify the law, take you to it and tell you what the law requires. Then you need to work with the product and technical teams because they are the ones that actually develop these products and they are the ones that can basically implement whatever measures you have in place to be able to ensure that you actually have a product that is privacy compliant. And then you would also work with management in certain instances. So it's important to know that it needs to be an exercise that is done holistically between these key departments in an organization. So now I'll go to the steps. The first step is identifying what your data processing activity is going to be. So, for example, now, if let's say maybe Meta develops a new application that allows you to communicate with data subjects outside Nigeria, like you need to be able to explain what that data processing is. Basically meaning we will be collecting data from people in Nigeria through using this app. The data would be moved from this place to this place and it will be stored in this particular server. So you need to directly, explicitly identify the processing activity. Now after doing this, you will now do a necessity and proportionality test. What does this mean? This means that you have to now consider what I want to use this information for. How much information do I need to take from data subjects to be able to do this data processing activity? Am I taking the information that is required or am I taking too much? Because, like my colleague spoke about data minimization, you have to ensure that you only take what is needed for that processing. So if you don't need to collect my biometrics for processing activity, don't collect it. If you can just do it with my name, my gender, my phone number, my email address, then stick to that. So that allowed you to consider, what do I need for this processing activity? Am I collecting enough data for that? So that's the second step. The third step is now mitigating the risks that can occur from this data processing. When I mean risks, what do I mean? I mean maybe risks of the data being mishandled or not securely stored, meaning that it could lead to unauthorized use of that information. It could lead to identity theft. It could lead to fraud. So you need to now identify the risks that could occur from my data processing activity. That's the third step. The fourth step is I've identified the risks now. What measures can I put in place to ensure that these risks are well addressed? A measure can be, like I spoke about earlier, the PETs, the privacy enhanced technologies. It can be ensuring that I don't use the specific information, I use sensitive data, or I don't take as much information as I actually need, as much information, I only take information that I need, so data minimization, so only take information you need. Another measure in place can be ensuring that your product is designed in a way, privacy by design and default. That means that there are some apps that you see today that you notice that taking of certain information is not on default. So you have to be the one to enable it. That is privacy by design technology. So that's a mitigation mechanism you can put in place to address whatever risk can occur. That's privacy by default, sorry. While privacy by design is only taking what you need from them, data minimization. So these are the sort of measures in place that you can put. Other measures can be security standards. So that can be your encryption methods. It can be access control. So ensuring that you have adequate policies that will state who can access data at certain and particular levels at an organization. Another measure in place can be training your staff, people that actually handle this data, to ensure that they understand what privacy means and that when it gets to them, they actually protect this data. So those are the 4 major steps that you would take in ensuring that you conduct a DPI in line with the Act. There are certain instances where you might have to submit your DPIA to the Commission, and those instances are outlined in Section 28 and Article 28 of Guide. Article 28 of Guide also now lists certain in specific instances where you have to conduct a DPIA. For example, if you are doing surveillance on a large scale, you have to do a DPIA. If you're using sensitive data, like your present sensitive data, like like biometrics, somebody's political information or affiliations, you have to conduct a DPIA. If you are present data of children or vulnerable groups, you have to conduct a DPIA, and in certain instances submit it to the Commission. So I think that gives a general idea of DPIAs.
Thank you very much again for the question. So on the data protection audits, I believe that's the only part that has been addressed because my learning colleague has extensively spoken on DPIA right now, so there's nothing more to add to that. Data protection audit is simply a formal structured review of an organization's data processing activities, and the essence of it is to really determine compliance with the available data protection laws, in this instance being the Nigeria Data Protection Act. So as a data controller or a data processor, you are supposed to have a record of your processing activities. And the reason for this is because you are supposed to demonstrate transparency in your data processing activities. So the record of data processing speaks to that principle of transparency, because one day the NDPC might just call you to bring them the record of your data processing activities and you start shaking, we didn't really keep it. You've entered into trouble with us. We're going to fine you. We're going to fine you heavily if you don't have a record of your data process, because how then do you file your audit returns, you know? So, and these audit returns, you file them through our DPCOs. They are the ones that carry out these services for us through our private public partnership. That's what we call it, a PPP model. So, like I said earlier, basically the essence of this data protection audit is to demonstrate compliance and also to show transparency in your data processing activities. So, if you wish, it's part of the first thing we'll ask you for when we are calling you for PAC. You know, it's one of the first ways that you can demonstrate compliance with the NDP Act by filing your audit returns. Thank you.
Thank you very, very much. With the kind permission of Compare, I'll just take one question from the audience if there's a question. All right, please. Thank you.
Okay, thank you very much to all of you. It's been very informative. I have 2 questions. One is just the direct question. We're talking about the DPCOs. How does one become a DPCO? That's the first question. And the second question is actually to discussions around data protection. We're talking only about technology and technology areas, but I don't think that is the extent of the cover, because especially in Nigeria, we have a lot of non-tech enabled business and areas that still deal with data and still deal with sensitive personal data. So how is that covered? How is that looked at? I'm sure the Act probably has some areas that look at it, but how is the enforcement also carried out? Thank you.
Thank you very much. I commend your efforts, sir. The question I want to ask is that earlier on you made mention of data controller and data processors. Now the question I want to ask is that is there no any defense provided under the Act for the controller or processors for non-compliance with the rules? Is there any defense, or there's no any excuse for them for violating this?
I'm going to take, okay, you say whether there's any defense available to data control. There's really no defense. There's really no defense. There's no defense at all. You are held strictly liable for whatever you do with the personal data of data subjects. However you carry out data processing activities, if it contravenes the act, we're coming for you. There's no defense that you can give that will make you escape. It's just as simple as that. Let me not go any further than that. Yes. Yes. Thank you.
Yes, that's very true. But no, no, no. He's very correct. It's actually strict liability. That's very correct. But let me see if I can say something that can ease your pain a bit. Okay. So okay. All right. There's no defense, right? But when we're considering fines, there are certain things that we would consider, right? And if you're in our good books in relation to that, it can actually tilt the degree of your fine. So that can, so if you look at section 48(6), we talk about what we would consider in deciding how much your fine should be. Do you understand? It's not a defense, but I'm saying that it's something that if the commission should look at, it's something that we can consider in deciding whether we should reduce your fine or not. So one of them is the level of cooperation with the commission. So for example, now when we have investigations, if we invite you for PAC, and PAC is generally an interrogatory exercise where we will do a holistic review of your data processing activities. If you're very honest and transparent with your answers, and we see that you have to an extent taken some steps in complying with the law, it's something that we'll definitely consider in deciding how much fine we should give you. And if we see that the number of data subjects involved are not that high regarding the risks or regarding the breach that has occurred, it's something that we can consider in reducing your fine. Yes. So what were some other questions that were asked? Oh, okay. So our website is www.ndpc.gov.ng. All the information you need is there. There's a tab that has to do with DPCO. It's called DPCO Requirements and Registration. If you click on that tab, you will see all you need. But in summary, you need to apply to us. You need to apply for a license to become a DPCO. That particular part of the website states what the requirements are, so that in your application you can list it. We'll review the application, and if we feel like you have the expertise, because we will be looking at your expertise and your certifications, if we believe that you have that, then we will now decide to give you a license. You also have to pay a 50,000 naira fee to apply. Yes. But then when we now approve it, you have to pay, I think, 2 million naira. I think every 2 years, I think. Yes, for every 2 years. And then that particular sum, you have to renew that every 2 years. But I don't think it's 2 million. I think it's 1 million when you're renewing it. But everything's on the website, basically. You can find the information there. Okay, yes. I don't know why I can't remember the particular provision in the Act that actually states that it doesn't just apply to tech, it also applies to data processing that is done manually. So the Act applies to data processing done manually. I think the reason why most times focus on tech is because these days, we're in digital world now, so many things are done by tech, and data is actually what fuels all this technology. So I think that's why there's a lot of emphasis on that. But if you go to our trainings, when we're talking about organizational policies, we talk about how people in organizations have to protect data. It can be as simple as ensuring that if you're working on information on your decks, please, we have like a clear desk policy in our office. So you have to ensure that you maybe make your screen darker so that people cannot see they're coming in, or you hide personal information. So it also applies to data processing that is done within organizations using hard copies and all that. So it's not just tech related. It applies to both manual and tech data processing activities. Thank you.
Thank you very, very much. So, Mr. Musab, final words, just very short, 30 seconds, if possible, please. Final words. Thank you.
Sorry, before I said my final words, in relation to the defenses, when you ask the question, I don't have the answer, but later on in the process, I discover some lawfuls in the Act, which is the offense is absolutely liability. But there is one instance where you will not be held responsible. That is where you are within the 15-month grace. That is the only defense you have. By the act, from the commencement of the business, you have about 15 months, if I am correct, right? For you to comply with the provisions of the act. Except within that time, if you are caught for non-compliance, you'll be held responsible. And my last word is going to be brief introduction about our association, that is Data Privacy Lawyers Association of Nigeria. But due to the time factor, if you are interested, just search on or log in into our website www.dplan.ng. Dplan is DPLAN.ng. You'll see all the information required, and do not hesitate to contact us. Our emails are there, the social media handles are there, even the WhatsApp numbers are there. Thank you.
Thank you very much. Thank you very much, Mr. Musab. I'm sure you've said all you have to say. Or are there any last words you would like to share? Just, Mr. Okun, 10 seconds. Strict liability. We will come after you if you don't. Thank you.
Just because young lawyers are very dear to me, I would say that as much as it's an attractive field, it is very attractive. There's so many opportunities. But it's important that you're continually reading about it. This sector is evolving every day. And it's a sector that you can't just consider Nigeria's laws if you really want to be a very good data protection lawyer. You have to consider other countries' laws, because data is moving constantly between different jurisdictions. So if you really want to be a good data protection lawyer, you have to ensure that you're reading on what is happening generally, different cases in the world and all that. So I would just say, immerse yourself in the law, immerse yourself in what is happening globally, and just be very consistent with ensuring that you keep abreast with developments in the law. Thank you.
Okay. A lot has been said already today, and I want to believe that we've gotten so much from what we've done here today. And I sincerely want to thank the leadership of the NBA YLF for putting up this program. I believe it's one that will be very, very beneficial to all the legal minds out there. There's a lot of opportunities in this ecosystem for lawyers, and I just want to encourage all of you to, do everything you can to get yourself immersed. This ecosystem is no longer just a niche or something about technical concern or whatever. It has become something of national security, business integrity. There's a whole lot of areas that you can put to it that we as lawyers can benefit from. So I just want to encourage everybody that came here to put what they have learned today into continue learning, because it's an evolving area. You think you've gotten it today, tomorrow something has come up that has changed from what it is already before. So continue learning and continue building yourself. There is a massive opportunity out there for you waiting if you decide to, engage yourself in this area. Thank you so much.
Thank you very much. So this is where we call the session to a close. If there are further questions to be asked, you can send your inquiries, of course, to. Is there a website? Yeah. Okay. Yes.
info@ndpc.gov.ng for your inquiries. Then if you want to report a breach, our website www.ndpc.gov.ng. There's a tab there that says report a breach. There's also a tab for important links. So you can report a breach there, and you can reach out to us on all our social media channels. But that info@ndpc.gov.ng, I would say, is the most effective way to get through to us. Thank you.
Thank you very much. Thank you very, very much for this session. Before we exit the stage, I would like to call on the National Secretary and the Chairman to take a group photograph with the panelists. Thank you very, very much.
Thank you very much. Please, just for 1 second, if you just have your seats, we'll be done in less than 7 minutes, please. But after then, we'll take pictures so that we don't go back and forth again. Please just give me a few minutes, so we will wrap up everything and then just take pictures. I hope that's okay. I'm so sorry for taking our time. Yes, please just have your seats. Yes. Thank you, everyone. So, like I said earlier, we will be done in less than 7 minutes. And I want to also appreciate the people online. There've been over 400 in attendance throughout the session, so over 500, right? And then we also have to just state clearly that we were not informed that the limit was 500. So this session was recorded and it will be uploaded on our YouTube page, the Nigerian Bar Association headquarters YouTube page. So immediately after this, you could just go and view the sessions again, and then also the slides will also be sent to all registered attendees. And so moving forward, like I said, I'll be done in less than 7 minutes. I've taken 2 minutes, so 5 minutes I'm done. So let's welcome Miss Osato Uwagbe. Please shoot me after now. I'm so sorry, but thank you very much. Please welcome her very briefly. She just had to just speak. Thank you.
Good afternoon, everyone. I want to commend the National Governing Council of the Young Lawyers Forum and also to the Data Protection Commission. Thank you so much for this program that took place today. I was at the Abuja Abuja Law Week program. I had to come back up because this is an area I love, and I like when she mentioned strict liability. I'm the National Secretary for the Administration of Criminal Justice, so strict liability now popped in my head. Like, I have to go back to my chairman and say, Madam, maybe this is something we can touch, whether it is criminal, whether it is civil. But regardless, I want to say thank you. Thank you so much to the Data Protection Commission. Thank you to our learned colleagues and also to the young lawyers who were also part of this. I wish someone had actually taught me this when I was much younger at the bar. Maybe by now I would have gotten, more experience. But thankfully, there's still time to grow. There's still time to learn. It is an emerging area, just as the committee is called. So, thank you all so much. Thank you for the opportunity.
Thank you very much. Yes, shoot me. So we have 2 more minutes. Let's welcome the chairman of the Emerging Practice Area Committee of the MBYLF for his closing remark. Mr. Adekunle.
Good afternoon, everyone. We want to especially thank our guests. NVC, thank you so much for honoring our invitation. Diplan, thank you so much for honoring our invitation, and my distinguished colleagues. And also, I want to recognize the presence of the YLF National Chairman, Timothy. Is unavoidably absent. Thank you, Timothy, for the love and support for the committee. I would like to especially thank the secretary, also Taba Agbo. Thank you for the support. And to my distinguished committee members, I love you guys so much. Thank you for making this a reality. Nonso, Uche, Dane, and everybody in the committee. Thank you so much for your sacrifices. And also to our fellow attendees, thank you so much for waiting till this moment. Thank you for joining this session. We're going to be sending, like Uche rightly mentioned, we are going to be sending the slides from NDPC. We had a meeting with the commission yesterday, and the head of legal has promised to send our request to the commissioner. That is, we want young lawyers in Nigeria across the federation to be participants and also to get a discount for the virtual academy, exactly, for the virtual academy, and also for the training, the DPO's training, exactly, certification. So we are hoping for a feedback, and I am sure Ms. Ibukun will also, channel our course rightly. And once again, thank you, everyone. A link will be sent now where we want you to register for your CLE points for all the attendees, both the virtual and physical participants. All right, on this note, I would like to present, okay, yes, on behalf of the committee, on behalf of the Young Lawyers Forum, the Nigerian Bar Association, we would like to present this to the head of legal. He actually told us he was coming, but he's not here, no, exactly. All right, so on behalf of the committee, I would like to call Mrs. Osato, please. Can you please help us do this? Mr. Sato, please. On behalf of the Nigerian Bar Association, Young Lawyers Forum. Yeah, help us present today.
On behalf of the Young Lawyers Forum of the Nigerian Bar Association, we want to present this to Mr. Babatunde Bangweye, the Head of Legal for the Data Protection Commission. Thank you for what you have done for the YLF. Thank you for all that you continue to do. Thank you so much also for the continued collaboration.
All right, please let's quickly take our pictures, the group pictures, and then we'll take a picture, all of us together. Please just 2 seconds, please. We're done. Let's take a group picture and then everybody together. Please don't go. Okay. All right. Okay, so we start with the panelists first. Panelists first, please. All right. Please, sir. Okay. All right. Okay, please, photos, let's do that quickly. So everybody together again, please. We're almost done. Nonso, please can you come forward? Okay, everyone together, please. No, please, everyone together very quickly. Everyone, please, as much as possible. Let's just have it. Please, let's take a picture outside. Outside will accommodate everyone. Please.
So this is the end of. So on behalf of the committee, I want to thank everybody finally for your presence, for your patience as well, staying till now. Thank you all so much. It was lovely to have you, especially to our virtual participants. Thank you all very much. You can look forward to more of this. This is just the first, and plenty more will happen. Thank you very much and have a very lovely day. Thank you all so much.